is 2024 Pride, and we have been discussing the court cases and the legislation that have given our LGBTQIA plus siblings the basic rights that, well, almost everybody else has. Like the ability to get freaky in the privacy of their own homes without getting arrested. That was a thing. Lawrence versus Texas. And the ability to get legally married. That was also a thing. Yeah. And we have finally arrived at the big one. Obergefell versus Hodges. Yes. This is the case that legalized gay marriage. Yeah. Fun fact, Obergefell versus Hodges was not just one case. Originally, it was 6 lower court cases representing 16 same-sex couples, 7 of their children, a widower, an adoption agency, and a funeral director. I don't know where the funeral director came in, but there he is. And these cases came from Michigan, Ohio, Kentucky, and Tennessee. These 6 cases were condensed down from 6 into 4 cases. The first case is DeBeer versus Snyder. April DeBeer and Jane Rouse filed a lawsuit challenging Michigan's ban on adoption by same-sex couples so they could jointly adopt their children. Judge Bernard A. Friedman expressed reservations regarding plaintiffs' cause of action, suggesting they amend their complaint to challenge the state's ban on same-sex marriage. And then we have Obergefell versus Kasich. James Obergefell and John Arthur decided to marry to obtain legal recognition of their relationship. They married in Maryland on July 11th. After learning that their state of residence, Ohio, would not recognize their marriage, they filed a lawsuit. Obergefell versus Kasich in the United States District Court for the Southern District of Ohio on July 19, 2013, alleging that the state discriminates against same-sex couples who have married lawfully out of state. And then we've got Burke versus Bashir and Love versus Bashir. Gregory Burke and Michael DeLeon, who were legally married in Ontario, Canada, filed a lawsuit in the U.S. District Court for the Western District of Kentucky, challenging Kentucky's refusal to recognize their marriage on behalf of themselves and DeLeon's 2 adopted children. They later added as plaintiffs a couple married in Iowa and another in California, and the 4 children of one of them. On August 16th, a 4th couple married in Connecticut filed a related suit in the same court, but then joined the suit as plaintiffs. Named as defendants were Kentucky Governor Steve Beshear and Attorney General Jack Conway, as well as Sue Carol Perry, Shelby County Clerk. Their suit, Burke versus Beshear, argued that Kentucky should recognize same-sex marriages from other jurisdictions, and, well, countries in this case. And then finally, we've got Tanko versus Haslam. Local attorneys, supported by the National Center for Lesbian Rights, filed a lawsuit in U.S. District Court for the Middle District of Tennessee on behalf of 4 Tennessee same-sex couples seeking to require Tennessee to recognize their marriages. They argued that the state's policy constitutes discrimination on the basis of their sexual orientation and violates their rights to due process and equal protection, as well as their right to travel. One of the couples married in California in 2008, and the other 3 married in New York in 2011. They contended that Tennessee's refusal to recognize their marriage was a unique departure from its rule that a marriage valid where celebrated is valid everywhere. Now, November 2014, court rulings from the 4th, 7th, 9th, and 10th circuits ruled that state-level bans on same-sex marriage were unconstitutional. But the 6th Circuit ruled that it was bound by Baker versus Nelson, which found that such bans were constitutional. Remember, we talked about Baker versus Nelson. That was back, 1970, a lawsuit in Minnesota, right? They said that the same-sex ban was constitutional. This created a split decision between circuits, and it led to a Supreme Court review. And I remember reading that at the time, one of the justices was like, "You did this on purpose. You forced a Supreme Court review, didn't you? I see what you're doing." Regardless, the 6 cases, which had been combined down into 4, was then combined down into 1, Obergefell versus Hodges. And tomorrow, we will talk about the Supreme Court decision.